Welcome. Today's video covers due process rights under the 14th Amendment, including prosecutorial misconduct and the presumption of innocence, and comes from Dhar Mann's channel. A link to the original video can be found in the description below. In February of 2021, entrepreneur and film producer Dhar Mann posted a video titled, "Prosecutor Sends Innocent Black Man to Jail," which is a short film intended to portray the prejudices certain groups have had to face in the criminal justice system. We will review this video for legal accuracy, and since this video takes place in Pennsylvania, all statutes and case law will be from that jurisdiction.
So you see, Your Honor, it's without question that this defendant did these crimes.
It is a common legal misconception that defendants facing jail time for serious charges frequently attend court in prison jumpsuits and physical restraints. However, this is highly unprofessional and in many cases unconstitutional. The United States Supreme Court said in the 1976 case of Estelle v. Williams, the state cannot, consistent with the 14th Amendment, compel an accused to stand trial before a jury while dressed in identifiable prison clothes, and in the 2005 case of Deck v. Missouri, the court said, the 5th and 14th Amendments prohibit the use of physical restraints visible to the jury absent a trial court determination, in the exercise of its discretion, that they are justified by a state interest specific to a particular trial. Similarly, in the 1976 case of Commonwealth v. David, the Pennsylvania Supreme Court said, an essential element of a fair trial is the presumption of a defendant's innocence. Thus, a defendant should be allowed to wear the garb of innocence and should not, absent exceptional circumstances, be physically restrained while before the jury. It should be noted that, although this video portrays a bench trial being held, the Supreme Court recognized in the 1968 case of Duncan v. Louisiana, because we believe that trial by jury in criminal cases is fundamental to the American scheme of justice, we hold that the 14th Amendment guarantees a right of jury trial in all criminal cases which, were they to be tried in a federal court, would come within the 6th Amendment's guarantee. Since the right to a jury in the 6th Amendment applies to all felonies, and the crime the defendant is being charged with is a felony, it should be the jury hearing the evidence and deciding the facts of this case, not a judge. As the Third Circuit Court of Appeals said in the 2018 case of United States v. Warren, this right, in conjunction with the Due Process Clause, requires that juries decide all questions related to whether a defendant's conduct meets the elemental definitions of a charged crime. Therefore, the case in this video should be a jury trial, and the defendant should neither be handcuffed nor in a jumpsuit as is portrayed here.
No, that's impossible. I wasn't in Philly when it happened. I was in LA at a Dodgers game.
The Pennsylvania Supreme Court said in the case of Commonwealth v. Clinton, a man charged with crime is not required to explain anything. It is the Commonwealth's obligation to prove guilt. This right of an individual to remain silent is fundamental to the preservation of due process. As the Supreme Court said in the 1964 case of Malloy v. Hogan, the Fifth Amendment's exception from compulsory self-incrimination is also protected by the 14th Amendment against abridgment by the states. Consequently, as stated in the Pennsylvania Supreme Court case of Commonwealth v. Rodriguez, it is beyond question that a defendant has an absolute right to refrain from testifying. Nonetheless, every criminal defendant is privileged to testify in his own defense, according to the case of Harris v. New York. If a defendant does choose to testify in his defense, he is testifying as a witness. Therefore, all the rules of witness testimony would apply to him as with any other witness. The defense counsel would request him to be brought to the stand for testimony and both the defense and prosecution would take turns questioning him. The defendant would not be allowed to stand up and refute the prosecution at will. It should also be noted that testifying at trial can be risky as it involves a complete waiver of the right to remain silent and will thus allow the prosecution to use the exercise of that right against him.
He's lying. You can tell by looking at him.
Order.
Most jurisdictions follow the guidelines of the American Bar Association with regard to professional conduct of their lawyers, and Pennsylvania is no exception. Under Section E of Rule 3.8 of the Pennsylvania Rules for Professional Conduct, the prosecutor in a criminal case shall refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. A prosecutor who fails to obey these rules may be subject to a disciplinary hearing by the Judicial Review Board. Also, because of the prejudicial effect of statements such as this, they can sometimes result in a mistrial with prejudice, meaning the charges against the defendant could be dropped and he would not be tried again. The standard to request a mistrial with prejudice, however, must be balanced with the public's interest in ensuring justice. Consequently, a mistrial with prejudice usually will not be granted unless the prosecutor's comments were made intentionally, knowingly, or frequently, and had a potential effect on the outcome of the case.
Defendant, do you have any proof of your alibi?
No, we don't have any proof, Your Honor.
Okay. Well, if there's no evidence to corroborate Robert's story, the court finds the defendant, Robert Williams, guilty on all 6 counts of assault with a deadly weapon.
Wait, what? What? No! No! What?
No! No, please. Please, not my baby boy. He didn't do it. I know he didn't!
Your Honor, please. You have to believe me. I'm innocent. I put that on my life. You know I didn't do this. You know it.
Order! Mr. Williams, that's enough. Not another word. We'll reconvene tomorrow for sentencing.
Daddy! No, please! Don't go!
Everything is gonna be okay, sweetie, I promise. Daddy loves you so much.
Hey, boss. What if he's telling the truth? What if we got the wrong guy?
Well, you don't think I know what I'm doing?
No, I'm not saying that. I'm just wondering if maybe we shouldn't take another look at the facts.
I just want a case. Who cares whether he did it or not? All that's important is I'm one step closer to a promotion. And besides, people like him, they're all the same. Just a bunch of criminals.
Please, sir, please. It's never too late to do the right thing.
I wasn't in Philly when it happened. I was in LA at a Dodgers game.
Great work. He's innocent. He's innocent.
Can you give us a minute?
Yeah.
What are you talking about?
He wasn't in Philly when it happened. His story checks out. Look, I have his credit card statements right here. He was making purchases in Los Angeles while the crime was happening.
Okay. So?
Well, so if he was in Los Angeles when the crime was happening in Philadelphia, then it couldn't have been him. We have to get these to the defense right away.
Have you lost your mind? I mean, maybe somebody stole his card. Maybe he gave it to him. I can think of 1,000 reasons.
But, sir...
That's enough. The case is over. You hear me? Now what I would suggest that you do. Walk the line so you can get ahead.
In the case of Brady versus Maryland, the Supreme Court ruled that the prosecution has a constitutional obligation under the Due Process Clause of the 14th Amendment to turn over all exculpatory evidence, or evidence which may point to the innocence of the defendant, anytime the prosecution comes across it. As the Pennsylvania Supreme Court clarified in the case of Commonwealth versus Chamberlain, the Due Process Clause of the 14th Amendment requires defendants be provided access to certain kinds of evidence prior to trial so they may be afforded a meaningful opportunity to present a complete defense. This guarantee of access to evidence requires the prosecution to turn over, if requested, any evidence which is exculpatory in material to guilt or punishment, and to turn over exculpatory evidence which might raise a reasonable doubt about a defendant's guilt, even if the defense fails to request it. In this case, since the prosecution had the defendant's credit card statements, the prosecution would commit a so-called Brady violation in not turning this evidence over to the defense counsel. Such a violation could result in a mistrial. It could also result in a disciplinary hearing by the Judicial Review Board, as Section D of Rule 3.8 of the Rules for Professional Conduct also requires the prosecution to disclose such evidence.
I have proof.
What is it now?
I contacted a local convenience store, and I found a photo of him. He bought a hot dog just before the game.
It's not possible.
Take a look. He couldn't have committed a crime in Philly if he was buying a hot dog in LA.
Doesn't even look like him.
It's him. I had facial recognition confirm it.
Has anyone else seen this?
No, why?
Good. Let's keep it that way. I don't want you humiliating us or risking this case because you got some pictures that don't even look like the guy.
But, sir...
Quiet! You want to lose your job? I don't want to hear one more word about this case.
You're not gonna believe this. I have video evidence.
What are you talking about?
Well, a reporter was giving an interview outside of the game.
Okay, so?
So guess who walks by? There. That's Robert. He just walked through the background of the video. I can't believe this. This proves his innocence. We have to tell the judge.
All arise.
Have a seat.
We have to tell the judge.
You don't have to tell a soul.
Is everything okay, Mr. Graham? Anything you want to share?
No, Your Honor.
Very well. Mr. Williams, these charges against you are not minor crimes. Federal statute requires a 25-year mandatory minimum sentence.
No, please, Your Honor. I'm telling you, I didn't do it.
You've already been found guilty. So unless the people have anything else. This court hereby sentences the defendant, Robert Williams, to 25 years in a federal prison without the possibility of parole.
The United States Constitution divides power among two different levels of government, state government and federal government. The federal government is given the power to legislate over specific issues, such as interstate commerce, national currency, and offenses on the high seas. However, the Constitution does not delegate any authority to the federal government over purely local issues unrelated to any specific federal concern listed in the Constitution, so general police powers and criminal lawmaking belong to the states, not the federal government. This is why the Third Circuit stated in the case of United States versus Laudani, extortion or blackmail visited upon private persons in respect of their private rights or property are offenses which, under our federal system, have been left to the criminal administration of the states. Unless a need to protect some federal interest is present or inherently involved, conduct such as that described in the indictments is ordinarily left for condemnation by the states. Consequently, the crime of assault with a deadly weapon is properly analyzed under state law, not federal law. In Pennsylvania, this offense is considered a second-degree felony, which, as can be seen here, carries with it a much different sentence than what the judge claims. Also, Pennsylvania law generally entitles defendants to a parole hearing after half their time has been served. Contrary to popular belief, the judge's gavel is purely symbolic and bears no legal weight. A judgment is finalized once a judge formally enters his decision, whether or not a gavel was used.
It's never too late to do the right thing.
Wait!
Excuse me?
Wait, I'm sorry, Your Honor. He didn't do it. May I approach the bench?
You may.
Your Honor, there is no way that Mr. Williams committed those crimes. You see, I have here a credit card statement showing purchases made by the defendant with his credit card in Los Angeles on the same day that the crime took place in Philadelphia. And I also have a photo of the defendant in a convenience store here in Los Angeles buying a hot dog just mere moments before the crime took place. And I have a video as well, Your Honor, that shows the defendant at Dodger Stadium at the exact time and date that the crime was taking place in Philadelphia, over 2,000 miles away. So you see, Your Honor, Robert Williams could not have committed those crimes. He was telling the truth all along.
Is all this true, Mr. Graham? Why didn't you say anything?
Because he was more interested in his promotion than he was in saving an innocent man from jail. I presented him with all of this evidence, Your Honor, and yet he ignored it.
Well, what'd you expect? Huh? Okay, so maybe he didn't do this crime. But I'm sure he's done dozens of others. Look at him, he's clearly a criminal.
Your Honor!
Order! I've heard all I've needed to hear. Mr. Williams, the charges against you have been dropped. You're free to go. Bailiff, uncuff him immediately. And you, Mr. Graham.
Oh, please.
Obstructing justice and tampering with evidence is a very serious crime.
Your Honor.
I'm going to see to it that not only do you never practice law again, but that we send the right man to jail this time. You.
Compared to similar cinematic depictions of criminal justice procedure, this film from Dhar Mann is arguably one of the least accurate. In fact, there are even more legal inaccuracies in this video that we didn't cover. As a result, Dhar Mann Studios gets an F. It is undeniable that Dhar Mann sometimes posts good content on YouTube. However, content relating to the criminal justice system is clearly far from his strong suit, and it can be difficult to shed light on injustice in it while also showing a complete lack of knowledge on how it operates. I would highly encourage Dhar Mann to look a little deeper into the law if he continues to make videos like this.